The Honorable, the Supreme Court.
Good morning, everybody. Thanks very much. Please be seated. And when you're ready, please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled State of Vermont v. Damian Diaz, case number 24 AP 271. Representing the appellant, Damian Diaz, is attorney Alex Don. Representing the appellee, the state of Vermont, is attorney Evan Meenan.
Okay, thanks, counsel. Please come on up to the podium if you would, and before you start, introduce yourself and identify your client.
May it please the court, Alex Don of the Office of the Defender General for Appellant Damian Diaz.
Thank you.
Our Rule 29 claim in this case contains a number of different arguments, some of which are cascading arguments, and I'd like to take a moment to just provide a roadmap of what that overall argument is before I dive into the substance of the claim. First, our argument is that the state needed to prove that Mr. Diaz ran at JD with a knife because of the way the crime was charged to the jury, but it failed to do so. But our claim does not hang on that. If the court were to determine that the state did not need to prove that there was a knife, we have a number of other claims. Regardless of whether the state needed to prove that Mr. Diaz had a knife, the state failed to prove that he attempted to or intended to put JD in fear of imminent serious physical injury. First, if the state needed to prove there was a knife and the court determines that there was in fact a knife, the proof was still insufficient on the attempt and intent element because the knife or the alleged knife, the object that couldn't be seen, was concealed. So even if there was a knife, it wasn't being brandished in a way that intended to cause fear. Alternatively, if the state did not need to prove that there was a knife, then the evidence was insufficient to demonstrate that Diaz intended to or attempted to cause fear of imminent serious physical injury because Diaz, who was only 5'5", weighed only 100 pounds and wasn't alleged to have any other weapons, clearly wasn't attempting to put...
You put the size in your brief on the 5'5", 100 pounds, and I was trying to figure out what the significance of that was.
Well, it seems to me that it is unlikely that someone weighing 100 pounds could seriously be attempting to cause serious physical injury without any weapon, or that he would be intending to do so. Because the requirement for serious physical injury is actually attempting almost to kill someone, to, serious risk of death or something like that. So for someone that size, with not even threatening to punch, not waving his arms madly, literally just running without a weapon, 5'5", 100 pounds, I submit that it's just insufficient to establish without any weapon an attempt, a step in the direction of causing serious physical injury, which is near death. I'm almost at the end of my roadmap. Can I just finish the road? I just want to, so regardless of whether he had a knife, intent, and attempt, the property was not taken from JD's presence. And crucially, all of the elements of the crime were not present at the same time. And when I get into the substance, I'd actually like to start with that last requirement because it really goes to the heart of what the crime charged was. Assault and robbery criminalizes a very specific behavior, and it has a lot of elements and it has multiple intent requirements. But most crucially in this case, it requires that someone attempt, in this case, attempt to instill fear in someone of serious physical injury, while at the same time taking their property with the intent to permanently deprive them of that property. And that's clearly, the plain language of the statute clearly demonstrates that what they're trying to criminalize is basically the equivalent of a stick-em-up robbery, right? Give me your stuff or I'll hurt you. But in this case, we had none of that. The truth is the record doesn't establish that Mr. Diaz was even aware of, or certainly there's nothing in the record that establishes that he had any interest in or awareness of JD's property until JD was already in the house. The facts, uncontradicted, I think clearly
You're
show.
saying if there was initially just an intent to assault, and then quickly afterwards, after the property's dropped, there's an intent to commit larceny, you're saying that doesn't qualify for assault and robbery?
I'm saying that because the requirements need, because I'm not saying that what Your Honor described wouldn't be a few different crimes in the state of Vermont. Clearly, we can't have people attempting to assault people. We can't have people attempting their property, attempting to deprive them of property. I'm just saying that this crime, which is clearly designed to prevent people from doing those things with the mentality of scaring someone to get their stuff, wasn't present here. It may well have been other crimes. It was clearly criminal mischief or whatever the other convicted count was that we're not contesting the destruction of property. Now, in this case, when, according to the facts in the record, when Mr. Diaz ran towards the complainant, he wasn't brandishing whatever he may or may not have been holding. He wasn't waving his arms. And crucially, for this fourth prong, he wasn't saying anything about anybody's property. And there are portions of the record that indicate that he may well have been motivated, not by any desire to obtain JD's property, but out of a feeling of jealousy that JD was walking on the street with an individual who was at the time Mr. Diaz's girlfriend. So he sees someone behaving in a way that upsets him. He's jealous. He runs at that person. He shouldn't do that, regardless of whether he has something in his sleeve or not. But he's not, according to this record, intending to take anything from that person. He doesn't say, drop your bag. He doesn't say, give me your stuff. He literally just runs toward him, according to the record. The person goes inside. At that point, he's standing with the stuff, and we have a record from the individuals who are inside looking out the window. Neither of them describe a weapon or a brandishing or a threat or anything like that at that point. He takes the stuff, destroys the stuff. Shouldn't do that. But at that point, he's not threatening anyone. He's not running at anybody. He's not waving an angry fist. He's not waving a knife or a black thing or whatever. So on that last prong, our argument isn't that this is fine behavior. The argument is this is not assault and robbery, because there's literally not a shred of evidence that at the moment that any alleged menace took place, this defendant had any interest, let alone specific intent, in the stuff that was in the backpack. If there are no more questions on that prong, I'd like to.
Everything was concealed in the backpack. Or he was carrying a speaker or something, right?
He was carrying a speaker and wearing a backpack, but there was nothing in the record suggests that Mr. Diaz's interest was in any of that stuff. So JD goes into the home. He looks out the window and sees the destruction of stuff. If JD had come out of the home while Mr. Diaz was standing with the stuff, destroying it or picking it up and said, hey, that's my stuff, don't touch it. And if Mr. Diaz at that point had threatened him, right, with a weapon or otherwise, we would be in a different situation, because we would be using the threat of force to take someone else's stuff. But that's not what we have in this case. Even if all of the other elements that we have a problem with, even if our first three arguments fail, right? Intent, attempt, the physical menace, whether the stuff was in the property, even if we lose all those three arguments, the last one, looking just at what the clear purpose of the statute is and what the crime was as it was charged to the jury, the state just didn't make out a case.
Mr. Don, I guess a question I would have, answer this for me then. Your argument is that Mr. Diaz did not know what was in the backpack, so therefore no intent for the robbery. So what about somebody who, I had this happen to me one time. Someone pickpocketed me and took my wallet out of my purse. Didn't know that what was it they were going to grab, but got that, and that person was charged with robbery. So tell me how to reconcile that.
So we're not saying it's not robbery. We're saying it's not assault and robbery.
And
So,
robbery.
so when he picked up the stuff and destroyed it, I mean, I believe I researched this. We're not disputing that the destruction of someone else's stuff clearly evinces an intent to permanently deprive that person of the stuff. And I believe he also left with some other stuff and returned some or didn't stuff. So clearly that what Your Honor just described, robbery.
Right.
But assault and robbery all together at the same time, stick them up, give me your stuff. That's not this case. This case is, I'm mad at you, here's a backpack, I'm frustrated. But it's not, if you don't give me that, I am going to nearly kill you, which is what serious physical injury is. If the court would permit, well, I do think that that argument gets to really the core of, for the first time I've noticed my light ever, so I have 5 minutes. Okay, I'll just say, I think that argument gets to the core of why essentially the undisputed facts in this case they just aren't this crime.
But the state here has committed itself to a particular
Right.
way in which they say this crime was committed. Shouldn't they be held to that?
Thank you, Your Honor. Yes, I wanted to address that argument and particularly because I'm running out of time and want to save a little time for rebuttal. Your Honor's question goes to both the first piece of our sufficiency argument, which is whether the state needed to prove that there was a knife.
Right.
And then it also goes to the inconsistent verdict argument. But yes, the state in this case, or I'm sorry, the court in this case, when charging the jury,
Did the state object to that portion of the charge?
not only did they not, Your Honor, but they did not object when the same language was included in proposed final jury instructions that were circulated in advance of the trial. So I'd like to just briefly mention that when the court charged the jury regarding this count, the court initially says each crime's made up of elements, goes through some elements. But then when it gets to each individual element and expands on them, it says the third essential element is that Mr. Diaz made his attempt by using physical menace. Then one other sentence follows. And then here the state alleges that Mr. Diaz attempted by running towards him with a knife. From the jury's perspective, the court appears to be clearly saying this is the way that the state is saying this crime was accomplished. And respectfully, we argue that the court should be held to that burden. Unless there are no further questions right now, I'd like to reserve whatever time I have left.
Okay, we'll hear from counsel for the appellee, please. And before you start, please introduce yourself and identify your client for the record.
Good morning, and may it please the court. My name is Evan Meenan, and I represent the state of Vermont. I believe I have this raised as high as it can go, but
We
if
didn't
you have
get
any,
the we didn't get the 2X. We got the 1X.
thank you.
All right.
We had
Well,
this yesterday as well, same situation, but.
I'd like to start out this morning addressing appellant's arguments regarding the sufficiency of the evidence, and particularly his arguments about the proof that all of the elements were present at the same time. The state has two responses to that argument. The first of which is that when the evidence is viewed in the light most favorable to the state, which is how this court must view it, there is sufficient circumstantial evidence to prove that the defendant or the appellant did intend to steal JD's property at the point in time where he scared him into dropping them on the lawn of his friend's house. That evidence, that circumstantial evidence, includes the fact that the appellant sprinted at JD, that he was partially concealing something within his sleeve at a minimum to convey the impression that it was a dangerous weapon. In doing so, he caused JD to fear imminent serious bodily injury, and that is what JD testified to. And then the appellant unlawfully took the possessions that JD dropped, and then he violently destroyed them on the lawn. The state asserts that that evidence was sufficient for the jury to conclude that that the appellant intended to deprive JD of those belongings, even if the jury also concluded that the appellant was simultaneously motivated by his displeasure over JD speaking with his girlfriend. The state's second argument is that the jury could have permissibly found appellant guilty of this offense, even if it concluded that the appellant did not form the intent to permanently deprive JD of his belongings until after he forced JD to drop them by scaring him into doing so. And the state's argument is premised on the discussion in its brief of the Humphrey case, which is a very old case establishing that long ago, this court recognized that someone can unlawfully convert property for their own purposes and be guilty of a crime, even if their initial possession of the property was bona fide. The quote specifically is, even if the hiring of the horse had been bona fide and without any fraudulent design, the subsequent driving of the horse and wagon from St. Albans to Sherburne was an actual conversion by the respondent. So when all of these events are viewed in a very short period of time, it's clear that there's two permissible ways in which to uphold appellant's guilty verdict. I would next like to briefly talk about the evidence that the appellant placed JD in fear of imminent bodily injury, and specifically the appellant's repeated reliance on the fact that the appellant was apparently only 100 pounds and 5 feet 5 inches tall. We know that individuals are capable of committing incredibly violent acts despite their weight and their height, but we also need to look at the fact that the appellant was 19 years old and JD was 15. Now, 4 years does not necessarily seem like a long period of time to fully grown adults, but 15-year-old looking at a 19-year-old, sprinting at them while concealing something in their shirt, it's very scary, very, very scary, at least when the evidence is viewed in the light most favorable to the state. I would like to turn now to whether or not the state was required to prove that the appellant possessed a knife.
You agree that based on the verdicts, they did not prove it, whether that's separate from whether they had to or not. But based on the verdicts that were returned, did they prove it?
Well, that issue sort of gets into the second part of this appeal, which is whether or not the verdicts were inconsistent. I don't think that this court needs to resolve the particular issue of whether or not the jury concluded that there was a knife or merely that JD conveyed, or the appellant conveyed to JD the impression that he held a knife in order to uphold these convictions. Either conclusion would have been sufficient by the jury to conclude that the appellant committed assault and robbery, and it does not result in inconsistent verdicts.
But he was acquitted of the one count where carrying a dangerous weapon or a deadly weapon while committing a felony. That was an acquittal. And then in the charge itself, element number 3 talked about possessing a knife.
Well, the word charge is interesting because it could mean the information, the state's information, and that was not limited to possession of a knife. The language in the state's information did not specifically allege that the appellant possessed a knife. So that is
no to-wit language.
That's exactly right. So the state did not commit itself to proving that that was necessary.
It did in the jury instructions. There was no objection to the jury instructions, and the jury instructions were very specific. And so is there really any difference whether it was in the to-wit language of the charge or in the jury instruction?
The state's position is yes, there was a difference. And the state's position is also that the jury instructions did not inform the jury that they had to find that there was a knife to find the appellant guilty of assault and robbery.
Well, it was an element of proof. They say these.
It's not true, Your Honor.
The elements that the state must prove. That's the way I read the instruction.
That's not true. The state disagrees firmly.
And I mean, I'm not saying I'm right. I'm just saying, can you convince me that
Yeah.
I am
I
wrong?
will do my best to do that, Your
Thank you.
Honor. So when you read the jury instructions, and a good chunk of those is contained in the state's brief, as is usual in the state of Vermont, the court outlines what the essential elements of the offense are. Nowhere in the essential elements, in that portion of the jury instructions, did it say that an essential element was that the appellant possessed a knife. The essential element was that he physically menaced JD. Now, what the court did do was say, here, the state's theory of the case was that the appellant possessed a knife.
And that's the way the case was tried.
Well, that's certainly what the state tried to prove in its case in chief. However, the state is not required to prove every fact supporting its theory of the case, nor is a jury required to conclude beyond a reasonable doubt that every fact supporting the theory of the case occurred. The only thing the jury is required to do is find that all of the essential elements were met. And the essential element was physical menace, and physical menace can be accomplished without any dangerous or deadly weapon. That is why Section
And what's the
608.
purpose of putting that in the instruction then? The state asserts that threatening with a knife.
Well, it was not necessary to put it in the instruction at all. It didn't
The
have to.
state didn't say that at the time.
The state didn't have it. No, the state did not object. We acknowledge that. We don't think the failure to object renders the instructions, when read as a whole, inappropriate, because as a whole, they did breathe the true spirit of the law by accurately defining all of the essential elements. The state's theory of the case was that the appellant had a knife. However, it was not required to prove that to obtain a conviction in this case. The jury.
Instructions say that the state is obligated to prove each of these essential elements beyond a reasonable doubt, and they all have to be present at the same time.
That is correct.
And that's in the instruction.
That's correct.
So-
But not one of the essential elements was the possession of a knife. Not one. It didn't say that at all. When the court defined the essential elements, it did not say an essential element is that the appellant possessed a knife. It said the essential element is that the appellant physically menaced the defendant. And that is why we have two subsections in 13 VSA 608. 608B does require possession of a knife. If the state had
If
charged.
that was the state's theory, they could have very easily asked for a different instruction saying by threatening with a knife or by brandishing something that looked like a knife or something like that.
That's true. And in fact, the state did tell the jury that in its closing arguments. In its closing arguments, the state informed the jury that it could find the appellant guilty of assault and robbery without concluding that he possessed a knife. So it's clear that while the state was proceeding with a theory, both the court and the state clearly conveyed to the jury that it did not need to adopt that specific theory in order to find the appellant guilty. And that is why this case is analogous to the Bacchus case, where this court recognized that conveying the impression of possessing a weapon is sufficient under 608A to sustain a conviction, even if the jury concludes that no actual weapon was present. In the Bacchus case, that was the state's theory, that the defendant had a gun.
There was no comparable jury instruction in the Bacchus case.
Well, in the Bacchus case, I don't recall whether or not the jury instructions said specifically that the state's theory of the case was that the defendant had a gun.
Would that be important?
No, the state does not think that that is important, because again, what the state has to prove is each essential element beyond a reasonable doubt. I mean, this court's case law is clear. There's multiple cases that hold that. There's multiple cases that recognize the state does not have to prove every incriminating fact, and it doesn't have to prove its specific theory beyond a reasonable doubt. Now, it is different when there is a to-wit clause and the state is specifically committing itself to proving the language in the to-wit clause.
Why would the state have a to-wit clause if you say it's not necessary?
Well, because the to-wit clause in certain circumstances can help satisfy the constitutional mandate that a charging document provide a defendant with sufficient notice of the allegations against them. And in this particular case, that's not an issue. The appellant is not arguing that he lacks sufficient notice of what he was being charged with. But that is why the state in general does include that language. So it can identify, for example, what specifically what specific criminal act the defendant is accused of committing. In this case, the affidavit of probable cause was not sufficient, was not, significantly lengthy. The nature of the crime was clear, and the state did not lock itself into proving that there was a knife because it didn't include that in the information. And in its closing argument, it specifically told the jury, you can find the appellant guilty even if you conclude there was no knife. I believe I have approximately 3 minutes left. And with that, I would like to turn to the second part of this appeal, which is the issue of whether or not the verdicts were inconsistent.
Before you start, Mr. Meenan, I'm going to address a question to you directly on that point. Doesn't this court permit inconsistent verdicts to stand under Carpenter?
Yes, it does. And this court is not alone in doing that. The United States Supreme Court has recognized that inconsistent verdicts do not violate a defendant's due process rights. And it has warned other courts against adopting a rule to the contrary. For example, in the Powell case, it said, such an individualized assessment for the reason for the inconsistency would be based either on pure speculation or would require inquiries into the jury's deliberations that courts will generally not undertake. There's another case cited in the state's brief, and the specific name of it is eluding me now. I believe it was a New York case in which the court recognized that juries are allowed to make compromise verdicts. They're allowed to make mistakes, and they're allowed to treat defendants with leniency. And that when there is an inconsistent verdict, it could be because of one of those reasons. And courts should not automatically assume that the inconsistent verdict resulted in some kind of windfall for the government.
Wouldn't that be jury nullification, which is something Vermont doesn't allow?
I don't know that it. Well, I think that there's a difference between jury nullification and inconsistent verdicts. I think my recollection of the case law is that when Vermont says it doesn't allow jury nullification, my understanding is it does not allow a defendant to specifically get up in front of the jury and say, you should just, there are reasons aside from the fact that this, granted the state might have proved every essential element beyond a reasonable doubt, but I'm specifically advocating for jury nullification, find me not guilty anyway, based on various policy reasons or, some plea for sympathy, right? That it clearly is not allowed. And that's my understanding of the prohibition on jury nullification. I might be incorrect, but that is my current understanding. I think with the time left in my argument, what I'd like to do is distinguish the Krepalt case. I think I'm pronouncing that correctly, but I might not be, because that is a case that the defendant relies on pretty heavily in their brief. Now, that case might be controlling here, for example, if the appellant had been convicted of carrying a dangerous or deadly weapon while committing a felony and then acquitted of all of the underlying felonies. That would be a nearly synonymous situation to the Krepalt case, but that is not what happened here.
Okay.
Thank you very much.
Thank you. Your time has expired. How much time does the appellant have, please?
Appellant has 2 minutes and 52 seconds remaining.
Counsel, before you get going there, what do you say about the standard of review? Clearly, it's intended to be very deferential to the state's position.
On the inconsistent verdict argument, our position is that it's de novo review, and that's based on looking at what this court did in Crapo. The court basically just looked there's no reference in Crapo to deference, abuse of discretion, clearly erroneous. The case that the state cited in their brief, Wiggs, regarding the standard of review, states that appellant raised essentially a challenge to the jury's verdict and that the jury's findings are granted a great deal of deference. It wasn't clear to me looking at Wiggs, or I did attempt to go into the briefs online to try to figure it out. It wasn't clear to me that there was a preserved legal issue in the Superior Court regarding whether or not the verdict was inconsistent. And my reading of Wiggs was that it appeared that the appellate attorney was, for the first time, challenging the jury's verdict on various counts as inconsistent. In this case, the issue was brought before the Superior Court. The Superior Court ruled on the law that the verdict was not inconsistent. And our argument is that that legal determination should be looked at de novo by this court. On the merits of the inconsistent verdict argument, to answer Your Honor's question earlier, in Bacchus, the opposite happened than what happened here. In Bacchus, the court explicitly told the jury regarding the count of conviction, you do not need to find that the defendant was armed with a dangerous weapon to convict him of assault and robbery. Explicitly told the jury that. In this case, the opposite is true. The court did not give that instruction. Just to be clear, the court never told the jury anything along the lines of, you could find that there was a knife, but you could also convict if there wasn't a knife. Instead, the only language we have from the court regarding the knife requirement or non-requirement, however you look at it, is the court said, the third essential element is this. Here, the state has alleged. Our position is that by phrasing it in that way, the court essentially transformed that.
But Mr. Don, the court never said you are required to find a knife. Isn't that the language that obviously if that had been said, then I'd say you're right. But that language wasn't used specifically by the court. You're extrapolating then.
True,
Is that right?
sure, 100%. But what I'm submitting is we're attempting to imagine what the jury would have concluded hearing the language from the court, because obviously we're trying to figure out what did the jury in fact find. And my position is, and our position is, the third element of the crime charge was 3 sentences long. And the third sentence was, here the court has alleged that he ran at him with a knife. Under these circumstances, the jury clearly would have been left with the impression that a knife was required.
Okay, thank you very much. Your time has expired. Please call a conclusion of the hearing.